politics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American policy and politics. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined by the professor of law at Chase Law School, Ken Katkin. Welcome to the show, Ken.
Hey, it's great to be here, Trey.
Now, Ken, the last time we did the show together, we were trying to come up with your title, and you promised that you were, I had suggested the Midwestern Socialist, and you had laughed, and you said, I'll think about this, and I'm going to give it thought. I had wondered, have you given your title any consideration?
Oh, my God. I completely forgot about that. I'm so sorry. I will, give me one more episode to come up with one. I just totally forgot that, so I didn't do anything.
No, that's all good. Well, it's a good point, because as a matter of fact, we're going to be doing the next show as well. And so this is a good time to kind of let listeners know. We're going to be taking next week off. It's our traditional holiday break. It's Christmas next week. And so next week, there will not be any episodes of The Politics Guys. But then Ken and I will actually be back the following week, a little bit early, so that you don't have to wait quite as long. We'll have an earlier show for you coming out next week. So Ken, over the break, what you're going to have to think about is your title.
Yeah, I'll come up with something that you can call me.
Okay. Now you make it sound like an insult. We don't want to just call you. We want to knight you with it. We want to kind of think about it in this positive tense.
Then I better come up with a good one.
Okay, so listeners, why don't I lay out what we're going to be doing on the show this week for me and Ken? We're going to start with this week's big news for the criminal contempt vote in the House with Mark Meadows. We're going to begin there. And then we'll expand on that story to talk a little bit more about what's been coming out of the January 6th committee itself. After that, we're going to move south. We're going to talk about the Texas lawsuit and specifically what's happening vis-a-vis the Supreme Court and the way it remanded it back. We'll also talk a little bit there about how other states, in this case California, have been potentially using this same unique, I will say for now, mechanism to potentially have gun laws, something that we had talked about on the show before. We'll then move to some even more breaking news. We'll be taking a look at Russia, specifically its demands this Friday morning concerning NATO. We'll talk about its buildup on the border with Ukraine and how that relates to American politics and to NATO. Then we'll also be talking about Omicron, specifically what some of those policies ought to be as we're taking a look into the winter. We'll talk about the Biden administration's petition to the United States Supreme Court on that front. We'll also take a look at Congress's raising the debt ceiling by $2.5 trillion and a little bit about the CBO's newest rating on Build Back Better. So we've got a big packed show, Ken. So before we get into anything, we're just going to take a quick break. Okay, Ken, well, welcome back. Why don't we get started with the show? And let's get started with Mark Meadows. This past week, it was the full House voted to find Mark Meadows in contempt of Congress. Now, this matter, of course, moves now along to the Department of Justice, where they're going to have to determine what they're going to do. Now, we actually got to talk about a similar circumstance. We had made some predictions on this for Steve Bannon, where the DOJ moved relatively rapidly to bring those charges against Bannon. Now, in that case, it was a different matter because Bannon, as we had pointed out in the show, is a private citizen, right? He doesn't have, and was during the period for the communications. And so as a result, he doesn't have any kind of claims for things like executive privilege. Meadows, on the other hand, was working as President Donald Trump's chief of staff. He has provided documents to the Select Committee, but he's arguing also in court because he is sued that the subpoenas are overly broad and is specifically refusing to testify. And it is his refusing to testify which ultimately led to the contempt vote. That contempt vote, which happened this week, passed, but of course with only 2 Republicans crossing the aisle to pass it. So obviously there's kind of two major elements here, Ken. One is the focus on Meadows, and I think we want to kind of focus there, both what we think the DOJ is going to do, his suit, and then I would like to kind of get a little deeper into the weeds of the documents he's provided so far and why those documents suggest why his testimony may be so key, so we can get a little bit more deeply into that. But I mean, where we might want to start here, I mean, something that we didn't have to deal with Bannon is this executive privilege argument, right? So last week, on Thursday, a federal appeals court ruled against former President Trump, saying there was, quote, a unique legislative need for documents. He had tried to halt this. In other words, they had narrowed what they were talking about for his executive privilege. We're seeing this coming up again. I don't think this is going to be the last time we're going to be hearing about this legal argument. So I thought maybe, Ken, you could just start by running us through what really is executive privilege, so that we can then maybe start talking about it in terms of Meadows.
Yeah, so I will talk about executive privilege, but even before we start that, I want to bracket it by noting that although that's the one you're hearing a lot about right now, I think as things move forward, the privilege you're going to start hearing a lot more about is not executive privilege, but the Fifth Amendment privilege against self-incrimination.
And I wanted to get to that too. Yeah, and I think you're right. We've already heard that there, individuals could be pleading the Fifth, and that's a unique. So yeah, please do both.
Yeah, so I think both Jeffrey Clark and John Eastman, the two lawyers who were the sort of principal architects of the legal theories that underlied the coup, they've actually already pled the Fifth Amendment rather than executive privilege. So their grounds for why they won't talk to the January 6th committee relate to their claim that crimes were committed and they don't want to incriminate themselves. And I think that that's going to be the direction that we see most of these claims moving in, because there's firmer ground there for people who don't want to testify. So executive privilege, to come back to that, executive privilege is a judicial doctrine. It's not something that is spelled out anywhere in the Constitution, but it is something that has been recognized by the U.S. Supreme Court, really beginning in the United States versus Nixon case in 1974, the Watergate tapes case, which Nixon lost unanimously. So even though the court recognized executive privilege in that case, not a single justice was willing to actually apply it to the Watergate tapes case. So what it is and why they wouldn't apply it there, the concept of executive privilege is an evidentiary privilege along the lines of other kinds of evidentiary privileges that exist in the laws of evidence. So that may sound technical, but the big idea is there's certain kinds of conversations or communications that people might have with each other that normally would be things that they could be asked to disclose in court, but in the law of evidence, there's some rules that allow certain conversations to be withheld from court, even if they're relevant to the disposition of a case. The most well-known one would be the attorney-client privilege. So if a client talks to their lawyer about the facts of their case to help prepare their case, the party on the other side is not allowed to subpoena the lawyer and say, tell us what your client told you. Even though that probably would be truth enhancing, because the court probably would be able to get to the truth better if it knew what the clients had told their own lawyers. But the idea is that there's an even stronger public policy interest in making it possible for people to hire lawyers, and nobody would ever hire a lawyer if doing so would mean that everything they told their lawyer would be disclosed to the other side. Other kinds of rules like that in the law of evidence would be things like the spousal privilege. It's generally not permitted to subpoena a spouse and ask the spouse what their spouse told them. And again, the idea there is just not to destroy marriages. There's a priest penitent privilege. So when people go to confession in religions that have confession, the priest can't be subpoenaed and asked to disclose what was confessed. And I think there the idea is that priests probably wouldn't disclose it anyhow, and there'd be a public policy against just sending them all to jail because people gave confession to them. So sometimes you have these public policy reasons why certain information, particularly information about communications that took place, are shielded from disclosure in court even though their disclosure would actually help the court get to the truth in the individual case, even though the evidence, in other words, would be relevant. And so what the court said in United States versus Nixon is that much the same way that clients in litigation need to be able to communicate with their lawyers with a reasonable degree of certainty in the confidentiality of the communications, that the president needs to be able to communicate with his own top deputies about the conduct of the people's business. So if the president has to make hard decisions all day long, it's in the public interest that the president be fully informed and that the president have considered a wide range of perspectives and objections to different actions he might take. And so he needs to hear all the information that's available. He needs to hear all the perspectives that are available if he's going to be able to make decisions that are best for the public. And that means that he's counting on his top deputies, whose job is to talk him through these things, much like a lawyer's job is to talk their client through a case. That he's counting on them to speak frankly and fully and not self-censor themselves because they're afraid that their conversations will wind up being disclosed. And so that's the basis of executive privilege, that because the public has a strong public interest in having the president be fully informed on issues of public business, that his own top deputies who are involved in those conversations with him to fully inform him can expect confidentiality in those communications. Now, in the United States versus Nixon case, where a special prosecutor had subpoenaed the Oval Office recordings, there were audio recordings that were being made around the clock in the Oval Office by President Nixon. He was actually using a secret taping system that had been installed by his predecessor, Lyndon Johnson, who also used it. But there were tape recordings that would have disclosed what was being said in the Oval Office by everybody who was physically present there the night that the Watergate burglars were caught and the next day. And so the special prosecutor subpoenaed those tapes, and Nixon asserted executive privilege as a basis not to turn over those tapes. So the 9-0 court said, well, there is such a thing as executive privilege along the lines that I just talked about. It's presumptively something the president can claim, but it's not absolute. It has limits. And if there are presidential communications that are bona fide evidence of crime, whether it's the president's own crime or whether it's the someone else's crime that might be prosecuted in court, then that evidence can't be concealed on an executive privilege theory. And if the president is making a claim, well, I can't turn over any of these tapes because none of it is crime, but all of it is privileged, then what the court said in the Nixon case is, well, that's going to be contested. And so the way that has to be resolved is the federal district judge who's managing the case, if in that case it was litigation, it'd be a little different here because it's Congress, but the federal district judge who's managing the case can look at all the materials in camera, which means secretly and privately. So he's the only one looking at it, and he can make judgments about that. And anything that he thinks is not evidence of crime, he can return to the president and never let the person who subpoenaed it look at it. But anything that he thinks is evidence of crime, he can turn over to the prosecutor and they can make it public. So there's been a little bit more debate about how that applies to congressional subpoenas, where you wouldn't have a federal district judge in that position. But the basic concept, I think, not necessarily the mechanism, but the basic concept that executive privilege is presumptively there to protect communications between the president and their top deputies about the public business, but not absolute. Not there to protect evidence of crime, and not really there to protect conversations the president has with other people who aren't his deputies. And that's where the Steve Bannon thing is on very weak ground, I think, for Bannon. Those are sort of the concepts that the court has spelled out over the last 40 years, 50 years now almost. Yeah.
Well, then here's my question, because that's the kind of the direction I thought you were going to head. So it seems to me, and you already had brought this up in terms of pleading the fifth, one of the elements in the Nixon case is this question of whether or not you potentially have crimes. But if other individuals are already pleading the fifth, doesn't that presuppose that there must be certain kinds of crimes taking place around the materials?
Yeah, I think so. I mean, I think that itself is, relevant if for you and me, if we want to think about what do we think's really going on here. Yeah, it seems that means there's crimes. I think that wouldn't be directly relevant if this was being if this litigation had come from if this subpoena had come from a prosecutor.
Yeah,
rather
that's what
than
I was
from
asking.
Congress.
The prosecutor. Yeah, continue.
Yeah. So if it came from a prosecutor rather than from Congress, then the determination of whether the materials are evidence of crime would be made by a federal district judge who's actually looking at the contents of the communications, and not it wouldn't be exactly relevant whether other people had taken the fifth. And other people have the right to take the fifth, and people could take the fifth even if there's no crime. One of the reasons we have the Fifth Amendment is the idea that even where there's no crime, experienced prosecutors know how to make people say things that will sound incriminating. And so we do have the Fifth Amendment partly to protect that idea that, ordinary people can be tricked and tripped up by experienced prosecutors who can make them look guilty of things even when they didn't do anything. That's one of the reasons people have a right to take the fifth. So I think when people do take the fifth, as a practical matter, as a realistic matter, there probably normally has been a crime and they don't want to be implicated in it. But at least from a legal perspective, we don't know whether there's been a crime or not.
Well, Ken, I'm going to pause this for just a minute, and we're going to pause for a potential brief word, and we'll be right back. Okay, so Ken, we had left off and we were talking about specifically the Fifth Amendment and how a crime doesn't necessarily have to have been committed. It's a mechanism of protection. And that was something you had mentioned earlier on, too, in terms of the different kinds of privileged communication. Meaning that there are certain things where you can't force individuals to provide information in a court setting, discovery. And I think for, listeners sometimes, this might be a little bit confusing, these ideas, right? Because I think there's this kind of broad level conception that what courts are fundamentally about is getting at the truth. And one of the things I always attempt to explain to my classes is that if you're concerned about justice, you can't maximize a desire for truth necessarily, right? Because justice presupposes that you have certain kinds of rights and privilege. And so that's really what we're getting at here. And so one of these privileges, as you were outlining us before the break, was executive privilege and how it works. And specifically, you're saying in terms of the Nixon case, that if you're going to have this, you would have generally a judge handling it. In this case, we've got Congress, so that in the specifics, it may not work the way, obviously, that it had with the proceedings of the Nixon. So what do you think the DOJ is going to do with this criminal contempt vote against Meadows?
Well, I think they're gonna wait and see if he pleads the fifth. I think if Meadows takes the Fifth Amendment, he will not be criminally prosecuted. But I think if Meadows continues to assert executive privilege without taking the Fifth Amendment, I believe he will be criminally prosecuted because his executive privilege claim, I think, is frivolous for maybe three different reasons. And before we saw the events of the last week or two, like I think when we talked about this a couple weeks ago, I expected that he'd have a little bit more merit to his claim because he was in fact one of the president's top deputies. He is one of the people that executive privilege would apply to. But I think the reason his case has become frivolous, he turned over thousands of texts and emails, and when he turned them over, he explicitly said that everything he was turning over were things that President Trump didn't claim executive privilege over. And so that's already kind of part of the record here. So if he's talking about materials that the President Trump didn't claim executive privilege over, that he's already turned over, and that in fact are very clearly evidence of crime because, everybody can see those texts and emails, then for him to say that he's not going to talk about them now that he's kind of got some buyer's remorse now that he turned him over and saw how that made Trump mad after all once, because Trump probably never knew what was in those things when he said turn them over. But now Trump got mad at me, so I don't want to talk anymore. I think it's a little late to claim executive privilege, not to explain materials that he's already turned over and that he himself has said aren't privilege.
Now,
the other
I don't want to
problem
interrupt you, but I do want to ask a question here, because this is your first point, and this is something that's different from the Nixon, which is my only primary experience with this. Right, in the case of the Nixon with it was all about tapes, document. Right, it was as a physical things. Right, in this case, it all hinges. Primarily, he's arguing that he shouldn't be able to be deposed, i.e., have to be answer questions. So my kind of follow up here, because this is something I'm curious about as well, is you've mentioned you've already given us this body of information. Is there any kind of precedent on the testifying portion? Because it seems that once you have evidence that you couldn't then say, I can't testify about the evidence that is already revealed. But again, I couldn't find anything about if there is any precedent on testimony in terms of executive privilege. I'd only seen it in terms of things, handing over documents.
Yeah. Right. Well, that's why I really mentioned the Fifth Amendment. I think that there's not precedent analyzing the distinction between testimony and documents in light of executive privilege, but that's a major fault line in Fifth Amendment privilege, right? So in Fifth Amendment right against self-incrimination, there's much stronger protections against having to testify than against having to turn over documents. So in the Fifth Amendment doctrine, there may be situations where the Fifth Amendment doesn't protect document disclosure, but the Fifth Amendment substantially always protects testimony. So merely invoking it and saying, I'm not going to give testimony because if I did, it might tend to self-incriminate me. That's usually going to be a silver bullet, and I think that still would be a silver bullet for Meadows right now. So that's what I think he may do. Now, I should also so I think if he only sticks with executive privilege, he's heading for criminal prosecution.
Yeah, it won't work. That was number one. You had two more, please continue.
So another thing is that President Biden, who is the president, has said that the White House is not invoking executive privilege here, and so for Meadows to try to say that he can that a former president can invoke executive privilege when the current president doesn't, there's no precedent for a claim like that ever being successful. And I think, although on the one hand I don't want to predict what this Supreme Court will do because I think they're very partisan and biased, and they might just side with Meadows because he's Republican. But if we separate it out from that and think about the theory of executive privilege, usually the theory of executive privilege is that if there's political brawls between the branches of government, the legislative branch, which is the Congress, and the executive branch, which is the president, that the courts don't want to get drawn into that.
Wait, I'm going to pause you right there. I think you mean the executive branch is the president and Congress, the legislative branch.
Oh, did I say that backwards? I'm sorry. Yeah.
It took me a minute.
The executive branch, Congress is the legislative branch. Yeah, I'm getting overexcited here, Trey. I'm sorry about that.
No, it's okay. It's okay. I just want to make sure I wasn't missing some judicial voodoo that I wasn't sure about.
No.
Okay.
No, yeah. So the executive privilege is a doctrine of separation of powers, and doctrines of separation of powers arise when there are conflicts between the branches. Now here there is no conflict between the branches. The Congress and the president are on the same page as each other. Biden is the president, and he is not invoking executive privilege. Trump is not the president. And so executive privilege is about protecting the interests of the executive branch. It's not about protecting the interests of individual persons. And so Trump's just an individual person. Biden speaks for the executive branch. So I think that both in terms of the complete lack of precedent for the kind of claim that Meadows is making, that the former president could ever invoke executive privilege, and even in terms of the theory of executive privilege, I think that would make it a non-starter. And the final thing I was going to say is that Meadows not only disclosed all these documents, but he wrote a book. And in his book, he talks about a lot of this stuff. And so that's completely inconsistent with a claim of confidentiality, right? That if we think of it as an evidentiary privilege and the idea is that there's communications that need to be kept secret and confidential, then that would be the idea that he wrote a book and he's making money, by talking about these same communications, seems to me to be very factually a fatal problem for an executive privilege claim.
So given that you've got these kind of three broad outlines, why do you think then that he's suing? Speculate with me a little bit here. Why sue specifically on executive privilege as opposed to potentially just going the route of the fifth? Why go that route if it seems so straightforward that he can't win?
Well, I don't know that he's forfeited his right to take the fifth. I think he can take it later.
Well, I didn't mean forfeit in that. I just meant why bother now? With the. I mean, he has an active suit going forward, or postulating that he has executive privilege. That these are overly broad subpoenas, and he has already provided enough material, and therefore doesn't have to testify. So if the grounds are is straightforward and shaky, as your three prong there suggests, why even make that argument and not go for the more solid grounds of the Fifth Amendment, even at the outset? That's what I'm asking.
So I think Jeffrey Clark and John Eastman have gone for the more solid grounds of the Fifth Amendment right at the outset, and of course they're lawyers. But I think with Meadows, the way I see that is, I think first of all, they don't want to have everybody take the fifth because that just makes it look like they all know there was a crime, right? And I think Trump is certainly pressuring people not to say, oh yeah, we all did a crime and we don't want to talk about it. I think he would still like to take the position that no, there was no crime, there was no criminal conspiracy. The White House was not involved in whatever the physical attacks on January 6th, et cetera. So I think for their political stance is that it's better to take executive privilege than to take the fifth. I think taking executive privilege and litigating it all the way out, if he loses all that, that doesn't stop him from taking the fifth after that. So he can certainly, keep that as a fallback if he needs it, but not have to take the less palatable political position early. It also gives him actually more room to delay. And one of the things they're doing is running out the clock, because I think they expect that after November of 22, the Republicans may regain the majority in the House. The January 6th committee will be over. And so just litigating all these things, could make them go away. So there's the delaying tactic there. And finally, I suppose it's possible they think that the Supreme Court is corrupt enough that it'll just rule their way because of who they are. And so they don't necessarily have to have a meritorious argument.
So, we've kind of been dancing. Now, we've all been focused on the procedure. We've been kind of dancing around what actually has been the content of what was coming from Meadows and what we're seeing from the January 6th, especially the text messages and others. And so what I really want to do now is kind of think a little bit more expansively. We can continue to talk about Meadows, of course, but in context of what the content of what he's provided to the committee. But before we get into that, I just want to let our listeners know that this is the portion of the show where we're going to be ending our free ad-supported preview. So you'll know that when we get to this point, we have a lot more to come in the show. If you want to have access to the rest of the show, if you've enjoyed the preview and you want to know more about what Ken and I are going to be talking about, you can get the entire episode, which generally runs closer to 2 hours, by becoming a supporter at patreon.com/politicsguys. You can also support the Politics Guys and get access to the show via PayPal by going to politicsguys.com/support, or of course through Venmo, where we're at Politics Guys. Now, again, we know that there's difficult times in people's lives. I've certainly been there. So if you'd like the full version of the show, but you're just simply not in a position financially to support the podcast right now, you can reach out to Mike at politicsguys.com and just let him know. And he's going to be happy. We'll set you up with access to the full episode each week. So I don't want to spend too much time here for our supporters as we move forward. But I do want to take a moment on the preview to support some of our absolute newest supporters. And I hope you guys will be enjoying the full show. William, Judy, Mary, Sean, a longtime supporter who recently increased his support for the show. Thank you so much. And Lewis, thank you so much for your generous contribution to the podcast through PayPal. We deeply appreciate that.